We have breaking news out of the state of New York involving New York's new gun control laws. We have a quick decision, an administrative decision, a housekeeping decision, mind you, but still a decision in the case of Anton Young versus Hochul before the Second Circuit Court of Appeals, the highest court other than the U.S. Supreme Court in New York. Stand by. I'll explain what's going on. A single judge has issued what's known as an administrative stay, which basically says that the TRO enjoining these state gun control laws has been stayed, meaning that the gun control laws are allowed to exist for the moment pending the assignment of this case to a 3-judge panel, which is happening literally any minute. So what happens is the state asked that the lower court decision that struck down the vast majority of these new gun control laws be stayed pending a decision on the appeal. And the state asked for this, and a single judge, an administrative judge really, although it's a federal court of appeals judge, basically said, I'm going to stay the lower court decision because I'm not going to be making this decision. This decision about the substance of the case under the Second Amendment is going to be decided by 3 Court of Appeal judges that are going to be picked any minute now. So I'm just going to maintain the status quo until this case goes to those 3 judges, and those 3 judges will be able to make a substantive decision on what to do. As you may recall, Judge Suddaby issued a decision that says a lot of these so-called sensitive places were unconstitutional as defined by New York, including Times Square. Judge Suddaby also says that certain requirements, such as turning over social media information to the government and an in-person meeting, is unconstitutional under the Second Amendment, but he allowed the state an opportunity to appeal, which is pretty straightforward. So let me tell you where we stand, because I don't want there to be confusion here, because it's the sort of thing that non-constitutional lawyers unfamiliar with this kind of practice might not get right. So Judge Suddaby is parallel pathing this case. And what I mean by this is Judge Suddaby in the United States District Court for the Northern District of New York is preparing for a preliminary injunction hearing. That is scheduled for October 25th. He is going forward with the case, and he's going to have a full-blown evidentiary hearing that's going to give New York a chance to show analogs that existed for these gun control laws in 1791. New York's going to try to argue late 19th century, which is completely wrong under the Constitution. And I'm going to get to that in the next video. I'll explain in detail why that's true. But basically, on October 25th, the fight's going to be as any of these gun control laws in New York are their historical analogs in the year 1791, which is the year the Second Amendment was ratified, that can uphold these laws. This argument will take place before Judge Suddaby on October 25th in the Northern District of New York. Parallel path now. What Judge Suddaby did is he entered what's known as a TRO, or a temporary restraining order. This is different than a preliminary injunction, because a temporary restraining order enjoins a defendant from acting in a certain way pending the hearing on a preliminary injunction. So Judge Suddaby entered a TRO, temporary restraining order, in favor of the gun-owning plaintiffs against the state of New York, saying all these gun control laws were likely unconstitutional. So the state has taken an appeal, an emergency appeal to the Second Circuit Court of Appeals, saying, hey, no, these laws need to remain in effect until October 25th, when we have our preliminary injunction hearing in front of Judge Suddaby. Now, in the Second Circuit Court of Appeals, the way it works is a single judge makes an initial decision on an emergency motion, which is what New York made. But it's very, very temporary, because all the judge does in this case, the judge that made the decision was Judge Eunice Lee, a Biden pick, by the way, but I don't think that matters. Judge Lee in this case just said, look, I'm not going to strike down these gun control laws in New York. I'm going to stay or pause Judge Suddaby's TRO decision, and then I'm going to refer this case in the normal course to a 3-judge panel. The 3-judge panel will decide what's going to happen during this TRO phase to New York's gun control laws. Now, we don't know who the 3-judge panel is, but literally they're being picked, I'm sure, as we speak, as I shoot this video. And what the 3-judge panel will do is they will schedule immediately a oral argument on this emergency motion, which is simply to determine whether or not the TRO, temporary restraining order in place between now and October 25th or so, whether or not that will remain in place, or will they allow the decision, or will they basically stay it and say, Judge Suddaby, have a full-blown evidentiary hearing, then decide what to do with the New York gun control laws, but we're going to stay it. We're not going to get rid of the gun control laws until you have your evidentiary hearing at the end of October. So that's really what we're dealing with now. Now, that three-judge panel is going to have an emergency hearing any day now. It could be tomorrow, it could be Friday. Whatever it is, they're going to have an emergency hearing, and they will issue a more substantive decision that will give us some insights as to where the Second Circuit comes down on the Second Amendment. But again, it's going to turn largely on who's on that panel. But either way, New York is absolutely not out of the woods yet. So here's an example. So New York Attorney General Letitia James issued a tweet right here that says a judge has ruled that New York's concealed carry gun laws will stay in full effect as the appeals process moves forward. It's not really accurate at all. All this court did, all this one judge said is, I'm going to let the New York gun control law stay in effect for a matter of hours or days at most until this panel decides the TRO, and it has nothing to do with what's going to happen down the road in a few weeks when Judge Suddaby has his preliminary injunction hearing. Remember, a TRO is this time period between you file the lawsuit and the time you have a preliminary injunction hearing, and a preliminary injunction covers the time between you have a preliminary injunction hearing to the end of the case, and at the end of the case, there can be a permanent injunction. All we're talking about right now is a temporary restraining order or a temporary injunction between now, dealing with New York's gun control laws between now and the preliminary injunction hearing decision, which, as we know, the hearing is going to be commenced in front of Judge Suddaby in the Northern District of New York on October 25th. So the Second Circuit is really only deciding what's going to happen here with this TRO between now and the end of October 2022. That's what we're deciding. And, we will get a sense of what this three-judge panel is. As soon as I know who it is, I will let you know. But for the moment, New York should not be too happy, because the stay they got protecting their gun control laws could literally only exist for a matter of hours, and it doesn't speak at all to the substance of the question. It's really a housekeeping process that usually is done as a courtesy, because Judge Lee is not necessarily even going to be on the three-judge panel, and usually those administrative judges just want to maintain the status quo until it goes to the three-judge panel, which is really going to get into the meat of the issue. By the way, as a side note, New York filed a letter with Judge Suddaby just at this, literally an hour ago, saying they want to submit a 95-page motion or argument explaining all the historical analogs that justify their gun control laws in modern America, in modern New York. I think they're going to get their butt kicked badly in front of a judge that's honest, and I think Judge Suddaby has certainly demonstrated to be honest and forthright and a serious jurist. So I think New York is in big trouble. But again, let's take a look at their papers and see what's going on. But for now, if you hear all this hyperbole about New York has got some administrative stay, do not put much stock into this. This doesn't tell us anything at all. It's a housekeeping issue. So sit tight, and I'll bring you further updates as the news breaks. Okay, hope you learned something here. If you haven't subscribed, please do so. We'll see you again soon here at the 4 Fox's Diner.
Orders up. Table 2A.